I'm feeling a little paranoid about next week and the threats of violence. And like, I'm not anybody important, but I'm an immigration lawyer. Am I totally paranoid, or have you guys been low-key wondering if you should get out of town for a couple days?
Oh, I don't think you're paranoid. Well, I mean, I don't think that sounds paranoid. We're closing our office. I don't know that there's going to be violence in Kansas City, but who knows? Definitely the government thinks there's going to be something. They've got more National Guard troops in DC right now than in several of the countries with which we're currently at war with.
I think you mean bringing democracy to?
Exactly what I mean.
Exactly.
I mean, being paranoid is not incongruent with being correct, right? I mean, those two things can happen at the same time. So we're closing our office.
Yeah, right. I thought about that and had basically decided to do that. I'm happy to find out that I'm not totally insane. So,
well, again,
right. I might be totally insane. I do want to give a little bit of a disclaimer. Normally, when one of us is feeling immigration lawyer dumps, we just don't record. I'm definitely feeling it, and we're recording anyways. And so I want everyone to feel super sorry for me. No, I'm struggling, but we're here today to talk about immigration law. So we're joined by Matthew Hoppock.
The smart Matthew.
The smart Matthew, friend of the show. Matthew, welcome to the show.
The bald Matthew. Well, thank you. Thanks for letting me be here.
We're going to have to come up with a different distinction because you guys are both pretty bald. So
it's a choice, though. I mean,
I feel like Matthew Hoppock is younger.
Yeah, I'm also a little bit shorter. Maybe I'm the short Matthew.
He's
taller.
Definitely more handsome. So
I think you're taller.
Let's just go with handsome Matthew and then, regular Matthew. No offense.
You two are too.
So Matthew Hoppock practices immigration law in Kansas City, Kansas, right? Kansas side?
I'm in the Kansas suburbs outside of Kansas City.
Okay. On the Kansas side, though.
Yep.
He's good friends with, what's that guy's name down there?
Chris Kobach. Yeah.
Chris Kobach, yeah. They pal around together.
Super tight.
I heard you guys were going to go into start a law firm together. Is any truth to those rumors?
No, there's no truth to those rumors. I wonder how much I can joke about Kobach. I was involved in the bar complaint that got him, well, not disciplined. He got a deferred adjudication or something like that. But yeah.
Okay, we'll move on.
I can say about Chris, but he won't be joining my law practice.
That you can confirm. All right. So now listen, Matthew, handsome Matthew. Last week, or whenever we last recorded, Matthew Archambault, regular Matthew, talked about being burned out. And he said something which resonated with me, which is this idea that we hear about being burned out, but it's, at least for me, it's always been like other people. And I'm sort of plugging along, doing my thing. But I'm really starting to feel it. And then you tweeted out you're maybe feeling a little bit of that burnout too. I mean, what's going on with you?
Well, right. So
we don't have to talk about this if you don't want to.
Well, I missed therapy this week. So no, this is super timely and helpful. I'm always hesitant about what I can tweet because I know I think some of my clients follow me and I don't want to alarm anybody like, hey, here's your attorney like melting down. But it's also important to not just be sunshine and roses if that's not how things are. And the truth of it is, I think we're all feeling pretty burnt out. I know I'm at least in the last 3 or 4 weeks, I try to stay on top of what's happening at the agency that runs the immigration courts and the BIA through FOIA and through checking their website every day. But in the last month, it just seems like an onslaught of rules and sneaky ways to get in policy changes because it's too late to do new regulations. If regulations get overturned by an immigration court, then you get a policy manual that says we're going to do it anyway. You get an attorney general decision that incorporates one of these regulations that's either already been overturned or going to be overturned. There are so many pending regulatory changes and then final regulatory changes and then court orders that have suspended those changes. I can't keep track of them all. I can't keep track of what is the current rule. There's a practice manual, just like the federal rules of civil procedure or local practice in courts, that the agency has a practice manual, but they keep changing it. They make changes to...
Didn't they get rid of it? I mean, you can't even get it anymore, right? You used to be able to buy it like in published form, right?
Right. So the way normal courts work is they have a list of their rules that everyone can access. And when they change it, they send you updates that you can then put the little paper-bound rule updates in the back of your book. And the whole thing is there and you know when it changed. With this, it's traditionally been a PDF that you could print out. And I've always printed it out and put it in a binder. And they didn't change it very often. So that was fine. But in the last few months, they've made so many changes, really substantial changes, like here's the deadline for filing your evidence is now half of what it used to be, or
twice what it used to be.
Now judges, they can require written pleadings, even though the regulation doesn't say that and the manual didn't say that. So all these changes. And then this week, they took the whole thing offline. The PDF is gone. And they put out this new policy manual, which incorporates the Immigration Court Practice Manual. But the version they released didn't include any of those changes, which means all of us are sort of scratching our heads saying, are they changing the deadline back to 15 days from 30? I start tweeting all the differences between the new policy manual and the PDF. And then I notice they're editing it as we speak. Like throughout the day yesterday, they continue to make changes. When you have a document like that and you're making changes, which any court or agency can do, that's fine. You just have to tell people you're making changes. And usually in the practice manual, there's been a table of changes in the back of it. But the table of changes in the policy manual is blank.
The good thing about this is that like in immigration court, the stakes are really low. So it's not that big of a deal if
Yeah, they're all about the do-overs in immigration court. You're exactly right.
Right. And it's not like somebody's, life or the future of their family or, none of those things are really hanging in the balance. So it's just low stakes, not that important. So
right. The way executive agencies are supposed to operate is they make rules that interpret how you apply the statute. That's their job. But there's a process to go through, which usually involves amending the regulations. You have to give the public notice and a chance to comment. You have to consider their comments. What this agency has started doing really suddenly is just avoiding notice and comment altogether. I assume because now they know they're almost out of time. But these are really, really significant rule changes. And I will say that has contributed to my burnout. The combination of not knowing what the rules are, with not knowing when any of our hearings are going to happen, with some of the courts being open and some of the courts being closed. They only announce it a week at a time if the court's going to be closed. Right now, we know about 15 days in advance. So that we've done a whole lot of wheel spinning in the last 6 months, and it's overwhelming.
This is anecdotal, but the experience I'm having out here in Seattle is that, and shout out to the fine folks at UIR Seattle. They're all great. So I've had a bunch of hearings. Almost all of my January hearings continued at the last minute. So these are cases that I've prepped for now probably 2 or 3 times that keep getting bumped. And I had a case scheduled for the 22nd and I was getting ready for it. And then somebody sent out on the AILA listserv, hey, it was scheduled with visiting judge 3. Okay.
That guy is the worst.
Very helpful and informative.
I will say visiting judge 3 is a fucking asshole. I'm not going to talk about any of the other judges, but this guy. So somebody sends out to the listserv that they had spoken to a clerk who said that all the visiting judge hearings were going to be continued for the month of January because they didn't have visiting judges. So I was really scrambling. I had my assistant got COVID. And so that kind of turns things upside down for a little while. And I'm trying to get this evidence together and update declarations and practice testimony. And I'm thinking it would be really nice to know for sure if that's the case. So I call the court and the clerk just says, no, I mean, it's still on the calendar and it's on the calendar. And I call again, a week later, no, it's still on the calendar and, you should prepare for it. And then it does get continued like 10 days before, after I've spent an inordinate amount of time getting ready. And who knows when it'll be rescheduled for. And what I'm hearing anecdotally is that the Seattle court is just absolutely drowning in work. They're trying to get out reset notices. They're canceling like 100 master calendar hearings per day and trying to get those notices out and drowning in mail probably, and then closing randomly because of potential COVID exposures. And it just feels like I don't know if this is a lack of leadership. I mean, what do you guys think the problem is?
Well, two things about that. So one, that seems to be a feature, not a bug. The process of only extending the closures by a week each time forces the court to only do a week of cancellations at a time. Most courts, all courts that I know of, other than this one, have closed until a certain date, and usually it's months. So then the staff can send out all of the cancellation notices. Instead, we have cases since the start of COVID that have been moved 3 or 4 times to dates that ended up getting closed again because the court's still closed. And so, of course, it's going to quadruple or more the work of these administrative staff. The other thing I'd say about your sort of who to blame question, that's the other big problem is there's no single person that feels responsible for these problems. The clerk who's putting it into the computer, it's not their fault. They're just coming to work. The IJs, they have to follow the scheduling, the EOIR director issues. I mean, the only person I feel genuinely okay being mad at is the EOIR director. James McHenry's made these decisions to run an inefficient, incompetent process that every other court in the country has figured out. And it genuinely seems to be on purpose.
Well, what I'm seeing here in Newark and in Philadelphia is they're canceling all these master calendar hearings, which is the preliminary hearings, and they're issuing scheduling orders. And all the scheduling orders I've gotten from Newark have been that they want written pleadings and applications for relief by, I think all mine are for like February 16th. And on the listserv, everyone's saying the same thing, like they're getting like dozens of these. So the court has to sit there and like send all these out. So that takes time. But what's going to happen is within a month, they're going to be getting hundreds and hundreds of written pleadings, applications, and then the government, DHS, is going to be getting the same thing. And they have 10 days to reply. So, and they talk about they're trying to do this to kind of get rid of the backlog. So they're going to have to go through each and every one of these in order for them to schedule them. And it is a logistical nightmare of their own choosing. And I don't know if that's McHenry coming down, but it would seem to me like the supervisor and the ACIJ at each court, like the one who's running Newark, should be a little smarter than to issue, hundreds and hundreds of scheduled orders for the same day.
Well, I think it's absolutely McHenry. And
McHenry.
Yeah, he's the one that issued the memo. So for the listeners, what this is about is December 1st, the EOIR director issues a memo that says, we're going to change the way we do scheduling hearings, master calendar hearings completely. We've done it the same way for 50 years. There's BIA and circuit precedent. There are regulations that require these hearings. I've decided we're going to do it totally differently now. And here's the new process. And it takes a good idea and turns it absolutely on its head. The idea is these scheduling hearings aren't always necessary because some people in proceedings really just want to get to the point. They want to apply for relief. And to get to that point, you have to go through pleadings and sustaining the charge and filing applications for relief. So there ought to be a way we can fast track those cases to get a trial set. Everyone agrees with that. And in fact, there is a way. We've been doing that for years. We file a motion that says, we're ready to proceed. Here's our pleading. Here's our form. Give us a trial date. Some parts of the country would call that a motion to vacate the master calendar hearing. Some would say it's a motion to waive. That's been in formal practice for years. But instead of saying, okay, we'll allow that practice, you choose when you want to waive the master calendar, the memo says anybody with an attorney now no longer gets a master calendar hearing. We're going to send you these scheduling orders and put everybody on this fast track. We get 45 days to respond. DHS gets 10 days to respond. And it does a lot of just nutso things. For one, it takes everything that the regulations require an immigration judge to do, explicitly says the immigration judge must do, and it says, hey, attorney, now you need to do this. You need to advise your client of the implications of these proceedings. You need to read the NTA to them and make sure they understand it. You need to advise them of their rights to an appeal. You need to, all the things that a judge is supposed to do is now on the attorney. The other problem with this, because they did it all at once, December 1st, the memo went out and these ACIJs have to comply with it, is, Matthew, it's not just one case that I've got 45 days to get my documents in gear. I have hundreds of cases pending before the immigration court. if they send a scheduling order in each case, there's just no way I'm going to be able to comply. It's not possible. I'll have to withdraw.
Right. Have you gotten any of those yet? Because Matthew's saying he's gotten them and I have not received any. So I don't know.
I've gotten 7.
I think they're sending them to the attorneys they know can handle it first. So,
okay.
These are for alpha attorneys. I'm sorry.
I'm on a beta list. They're saving us for later. Well, that's good.
What's also nuts on top of what Matthew said is we're getting these orders in cases where we've already filed pleadings and already filed applications for relief, which is supposedly the reason for the order. The order says within 45 days, you need to file your pleadings and your applications for relief. But in at least one of the cases we've gotten these orders, my client already did that at their last hearing.
Mm-hmm.
So,
yeah, and for the immigration practitioner who's listening out there, when you get these, I would really encourage you to push back in your written pleadings. Don't omit and concede. Don't concede proper service. Push back. Say you refuse to do what the judge is supposed to do. Make sure that's reflected in the respondent's declaration, because that will really put the onus on DHS, because DHS has 10 days to respond. So
in a lot of these cases, they don't file evidence even.
No, they won't file it, and they won't be able to.
Right.
If everyone really pushes it, they're not going to be able to do it. And the thing that is crazy is, so a typical master calendar hearing in real time, non-COVID, is you would sit down and a judge will say, have you reviewed the NTA with your client? You would say, yes. And says, hey, do you waive read-in and explanation of the charges? And you would say, yes. Okay? Because you could say no, and then the judge would have to read everything to your client and explain it. But it's a courtesy to the court. It's a courtesy to your client, so your client doesn't have to be there for any longer than they have to. It's a courtesy for all the other attorneys in the court. But what the court is doing now is, like, they're putting all the onus on us, showing us no courtesy. So let the producer get ready. Them, right? Just don't make it easy for them. It was a poorly thought out plan. I think there are ways to do it, like Matthew was saying, where you could say, hey, we encourage you to do this, because there are times you don't want to go for a master. You kind of want to move the case along and encourage it. But the way they're doing it is
right. And, there's a section of the memo. It's not just an insinuation. The memo specifically says, we're going to implement this new practice because people tend to waive the reading and waive the pleading. It says, removability is not contested in most cases, and representatives frequently waive the reading of charges and the giving of various advisals. To me, that's like saying, well, because most criminal defendants plead guilty, we're just going to skip the whole charging and pleading thing and assume they're guilty.
Right.
Because most criminal defendants plead guilty. Anyway, here's the statistics. Like, that's nonsense, because there are going to be cases where people can't waive the reading or admit all the allegations because they're wrong or whichever.
How is this supposed to work? Because they want pleadings and the application for relief, but presumably if you're denying removability or alienage, you can't then also file an application that has your alienage and evidence of your removability, right? So, I mean...
Yeah, I shared a template of the motion that I prepared. I put it on Twitter and on a Facebook group, and I'll share it with anybody who wants it if you email me. But all of this is laid out step by step in the regulations. First, you have to take a pleading. Then the judge sustains the charge of removability. Then you talk about which country is at question. You designate a country, the judge picks one based on your designation. Then the regulations say you apply for relief. When you have something like asylum, how are you supposed to apply for asylum when you don't know which country you might be deported to?
Right.
For some people, it's obvious because you were born there, you're a citizen of there. But for lots of people, it's not obvious because you were born in one country, but you're a citizen of another, or you were born in one country, but you lived for a long period in another. The regulations don't permit them to require applications for relief before the charges of removability are sustained.
Right.
But they don't care.
Matthew, like, you missed one. You said first they take pleadings. What comes before pleadings is the person being sworn in by the immigration judge and having their rights explained to them.
Is this your attorney?
And having the charges read to them and explained in plain language.
Right.
And so that has to come before they plead.
And in Matthew's case, is this your attorney? Do you want him to represent you? Are you sure? Are you sure?
Sir, do you need a moment? You can step outside.
How is your vision? Take a look at this guy one more time and tell me you want him to be your lawyer. I mean, these are all really good points. On the one hand, look, I'm a little bit sympathetic because we're dealing with a 100-year pandemic. Matthew and I just talked about last week. Before March of 2020, neither one of us had spent any amount of time in our entire lives considering like what a pandemic would be like or what we would do. And so the court was unprepared. On the other hand, this is a court that has been deeply, in my opinion, flawed since well before the pandemic. So it's not all the fault of COVID. I guess I'd like to ask you guys what you think needs to happen. And if we could set aside, I know there's the, like, let's just get rid of it. And I would agree with that. That would be a good solution. But if we could stick to things that we think are possible in the short term, what would you do if you were in charge and you had to try and right this ship?
Well, I can offer one. I'm not a fan of administrative closure because I do believe the whole thing should be torn down, start over. I think the entire system is corrupt. The concept that deportation is the consequence for some pretty innocuous stuff needs to be rethought. But you said that's off the table. Start with administrative closure. Until this current administration, if a case wasn't ready to be heard by the immigration court, you could ask the judge to administratively close it. This administration took administrative closure away. In fact, they said it's never been legal, even though we've been doing it for 60 years. So the way to get an administrative closed case back on the docket is to file a motion to recalendar. I was looking this morning at the statistics of motions to recalendar since that rule has changed, because they published them as part of their cost study for their new raising the filing fees. And the numbers of motions to recalendar are insane. In 2018, 8,000 motions to recalendar were filed. In 2019, 43,000 motions to recalendar were filed. And for 2020, we're on pace to double that. We're on pace for about 70,000.
Do you know if these are cases exclusively filed by DHS? Because I know if we have somebody consular process, for example, and they come back, we'll file a motion to recalendar and terminate.
Yeah, no, I think the numbers have been pretty static up until 2018. I think the case you're talking about fits into that regular yearly 3,000 to 5,000 cases a year range. Mm-hmm. The 43 and now 70,000 is all DHS moving to recalendar these cases to put them back in the court's docket. A simple solution would be these cases that are not ready because something else is pending or whatever. You have well over 100,000 cases they've forced back onto the docket that don't have to be there. We're not having hearings in Kansas City, at least. There's no reason for the court staff to have to continue issuing hearing notices for these cases. You could just administratively close a giant helping of these cases and take a lot of the burden off of both the immigrants, their attorneys, and the court staff.
I have a similar thing. I think all cases in immigration court, maybe set aside the detained cases, should be administratively closed, all of them. And if you want your case heard, the immigrant can file the motion to recalendar. And all cases that are administratively closed should come as a deferred action with the ability to get a work permit. And that should be in place until a total overhaul of the immigration court system.
Until we figure out what the hell is going on.
Exactly.
But like literally,
what the hell is going on.
Literally.
And quite frankly, I think any immigration judge or BIA member who has been hired in the Trump administration, they should be up for review. Because quite frankly, there are a host of them, none that I deal with personally, that are not fit to be immigration judges. And I really think they need to take that seriously. And then when that is finished, then maybe you can resume removal proceedings. But hopefully other things have intervened that will take people out of the removal arena. And again, to be clear for all the people listening, the whole system should be burned to the ground. But Stephen,
Right.
Stephen does not want to do that because in the heart of hearts, he is a cop.
I'm a neoliberal shill and I'm a Clintonian. I want to build that border barrier. No, I mean, I agree with you guys that the whole system, I mean, I just had one of the reasons I'm in the dumps is because of this hearing yesterday that just, on top of all this stuff you're talking about, Matthew, smart Matthew, the thing that really gets me about this job is, you get hyped up for these hearings. You really become intimately familiar with the client and the family. And then to have certain types of decisions issued where you feel like you're just getting gaslit a little bit about certain things, it can be really soul crushing. And I agree, like the idea that deportation is the solution to somebody driving without a license or something like that is absurd. I mean, the amount of harm being done, people are just getting crushed by the system. I actually really like the idea of closing everything. And then I think you could have a policy memo for ICE that says you're only going to move to recalendar whatever the metric is. And again, I don't think there should be a metric, but the people with the most serious aggravated felonies or whatever.
Yeah.
One of the issues, though, is also that we have clients whose only real form of relief is in removal proceedings, which is another sort of backwards part of this system that sometimes it's actually good for you to be in removal proceedings in a way. And so to give the respondents also an option to move to have their case heard would be good.
That's burning me out too. And even with the judges that I know are good and want to do the right thing, so much has been built into this system in the last 4 years that makes it impossible for them to, including quotas on immigration judges, that they have to complete a certain number of cases. There's been pressure from the top to only issue oral decisions and not issue written decisions. All of those are designed to speed up the judge. And when the judge is under pressure, they have to get a certain number of cases decided. What naturally would you do? I mean, I think the answer is they tend to issue these decisions that don't fully look into the evidence, that don't fully evaluate the person's eligibility. They just sort of become rote rubber stamp. Oh, you're from Guatemala? I've heard 100 Guatemalan cases this month. I'm going to issue the same decision that I've issued. So the language matches in a series of these decisions, even for good judges that I know came to the bench to do the right thing. It's really overwhelming.
I think if you did what Matthew is proposing and you closed everything and then you put it on the parties to recalendar and in special cases, you would also want to arm the judge with the discretion and the ability to look at the motions to recalendar and to say, you know what, I don't have time for this. Or maybe even if somebody files a motion to recalendar with their application for relief and their evidence and the case seems approvable on its face, to set the case for a 30-minute hearing in 2 weeks and just get the thing over with, right? But just to give the judge the ability to do that, and also to give the prosecuting attorneys, ICE, the discretion to agree to things like that. One of the things that's been frustrating about the Trump administration is, I remember during the Obama administration, an ICE attorney standing up at a master calendar hearing is full of people and saying, who wants prosecutorial discretion? Who wants PD? Like, who wants their case closed? It was like a fire sale for administrative closure. And now, if you try and call a trial attorney for ICE and say, like, hey, would you be willing to stipulate that, like, my client has the 10 years physical presence? Like, they're not allowed to agree to basic facts. They just say no, like, we can't.
Right.
Yeah, the whole thing is just so ham-fisted, but
I'm sure there are ICE attorneys that would love that type of change.
Oh, yeah, but plenty won't.
I mean, quite frankly, there are a lot of cases that we do that are going to be impossible to win in the best of circumstances, right? It's just the nature of the beast. But there are others that we do that really shouldn't even have to be heard by a judge. I have a 212C case. A 212C case is a permanent resident who has been convicted of a crime prior to, I think, 1997, but old crime. Like the one guy I have, I think his conviction's from 1990 or something like that. He's like in his 60s. And it was a minor drug offense. and he has nothing else. But, hopefully things will change and ICE will be able to just okay, and they can stipulate. But if the case was heard now, we would have to go through the entire hearing, to file documents, and we would have to put on testimony. It wouldn't be a hard case, but it still takes up time, and it's ridiculous because any immigration lawyer with half a year experience could look at the case and say, okay, this is a no-brainer, it's going to get granted. But we have to sit there and take the time, and those kind of cases clog it up. And it doesn't only clog it up for the court, right? It clogs it up for the client because this guy's life is on hold while this is going on.
Right.
And making it more like a real court in the sense where we can talk to the prosecutor and come to arrangements would be really helpful.
Just a quick tale of two cases to sort of highlight what you're saying. I had a case 2013-ish. It was actually with Jonathan Love, the forger at ICE. We showed up for the individual hearing, and he turned around and looked at the bench full of kids, qualifying relative kids, and he just said, yeah, you promised not to get in trouble again. And my client was like, yeah. He's like, all right, we'll stipulate. And the final hearing took 3 minutes. And I had a hearing about a month ago.
Is that because the chief had already taken the guy's social security number?
Jonathan Love and his boss had already run his credit score and found it was too low to do any good with. So they just, No, but I had a case about a month ago where I'd reached out to ICE, hey, similar facts, big family, lots of, equities. And no, they were not going to agree to anything. There was this long, drawn out cross-examination by ICE, on and on and on. And then at the end, the judge says he thinks that she qualifies. And the ICE attorney says, yeah, I think she's met her burden. When really nothing was garnered from the testimony that would have changed his mind. It was just an exercise in this is what the Trump administration says we need to be doing. And we don't need to be doing that.
Well, let me ask a broader question to Matthew, all these changes that are happening right now. And it's not only, there was a new asylum decision yesterday by the acting attorney general. All these things, and so many of them get caught up in litigation and all that. It's really confusing. It's hard to know what is going to happen. I sometimes have a sense I don't care. I just I kind of put my head down and say, hopefully everything changes. Hopefully all this gets undone. Do you think that's a possibility? Do you think that's realistic? Or
that's one thing that's contributed to at least my feeling of burnout is my job is literally to try to counsel people on what the future is going to look like, what certain decisions should lead to. And I give that counsel based on what I understand the system to be like. But not only have things changed so drastically, really in the last 4 years, but even in the last month or 2 months, but there's this underlying sense that none of it is real. And so how much time should you really invest in learning these new rules? I spent a good part of yesterday reading the new policy manual while they were editing it in real time. Part of what's overwhelming for me is not knowing what should I be spending my time on and which of these things are going to go away. I do think at least a good portion of the Attorney General's decisions are going to get overturned because they completely changed the asylum law in a way that's inconsistent with the immigration statute, the BIA precedent, and our refugee convention. So I think those are probably going away. I think some of these policy manuals are going away, but nobody from the Biden team has said, this is our immigration plan, or these are the specific changes that are coming. So a lot of it is just wishful hoping and thinking that maybe this new 30-day deadline will go back to 15 days, or perhaps we'll get administrative closure back. But honestly, I have no idea.
Now, you say that the Attorney General decisions changed the law, but the Attorney General decisions themselves swear up and down that they don't change the law. And I think that's proof dispositive that they don't.
You know what I love, though? Their decision goes at length to say that this decision changes nothing. So why issue the decision?
Everything is the same. And here's 15 pages about how nothing has changed whatsoever.
And there's another layer of that, which is super nerdy, and I'm sorry in advance. But at the end of saying none of this is new, nothing is changing, the Attorney General acknowledges that his decision is inconsistent with a number of circuit court decisions. Mm-hmm. And he invokes this process to get around those by saying, basically, I'm changing things because I find the statute to be ambiguous, so I'm going to change the way we interpret it, which is the exact opposite of what he said the previous 15, 16 pages.
Well, to get even nerdier, they throw smoke at the DC Circuit Court that kind of tore the original matter of AB apart. And the new AG that's coming in is going to be Merrick Garland, presumably he gets confirmed, who was, of course, a member of the DC Circuit. So I think that's going to go over well. So
I don't want to take up too much time because I'm supposed to have a staff meeting. Ugh, boring. But matter of AB was Jeff Sessions' effort to get rid of domestic violence and gang-based violence asylum claims. And it got kind of kicked around by a couple of circuits, and it wasn't a very well-written decision. And so just yesterday, they came out with a new matter of AB, which claims to not change anything. But essentially what their second bite at the apple is saying is that it's always been the case that, look, if you're a victim of some sort of persecution or crime in your country and you want to seek asylum, part of the analysis is whether or not your country, the government, is willing or able to protect you. So, I mean, yeah, crimes happen everywhere. That's true. But they're basically going to use this decision to say, oh, well, 98% of femicide in Mexico goes unprosecuted or uninvestigated, but there's 2% that do. And so it looks like the country is willing and or able to protect at least some people. And so therefore you don't qualify for asylum. That's how it'll be used. But then again, this goes back to what you were saying, Matthew, like, is this case going to be used? Is it going to be overturned in 2 weeks or in 2 years by the circuit courts? Like what? Yeah, it's very, very frustrating.
I don't know if you can use history as your guide, but when Bush was on the outs, his attorney general issued a number of similar decisions. One of them changed the law about motions to reopen for ineffective assistance of counsel. He issued this decision called Matter of Compion that changed everything. And when Obama took over, his attorney general didn't reverse Compion until June, I believe. So 6 months into his administration is when they finally issued a decision saying, yeah, forget that whole new rule that Bush established. I don't know if Biden will do the same thing. None of us knows really Merrick Garland's politics on immigration, but I sure hope it happens quick. I hope they don't wait 6 months.
Right.
Have they announced who else is going to be in the team, so to speak?
I haven't heard any announcement.
Have they reached out to you, Matthew?
Have they reached out to me? No.
Yeah.
No.
Okay.
I don't think I'll be getting that phone call. I was never an outspoken critic of this agency as much until this last 4 years. I started filing so many FOIA requests because the Trump administration became so non-transparent that the only way to figure out what the agency's current rules are or policies are was to file a FOIA request. I'm hopefully get to go back to not filing many FOIA requests under the new administration. But for the last 4 years, I've made, unfortunately, a lot of those. And yeah, I don't think they'll be asking me to come work for them.
All right. Well, we'll see. I would put you in charge personally.
Thanks, bud. Well, you can be in charge of my firm.
All right.
Great.
Sounds good. Thanks a lot. I appreciate that. Matthew Hoppock, thanks for joining us. Matthew Archambault also, likewise.
Thank you, Stephen.
In addition, and have a good weekend, guys. Try to take a little break mentally. Turn off your phone and
fill up your tank with gas. Stock up on canned goods, dried meats.
Mm-hmm.
It's snowing here. I'm going to go sledding, but yeah, I love you guys, and it's really nice to talk to you both.
All right. Likewise. Take care.
Bye.